Good morning, friends. Important video on one of the burning topic. We have seen that lot of taxpayer who wanted to avail pre-GST credit, which should be transition into GST regime by way of filing Tran 1 and Tran 2. And last date, as we know, that for filing Tran 1 was 27 December 2017. But we have seen a lot of glitches. Many taxpayers could not file their Tran 1 and Tran 2 for the region technical glitches on GST Common Portal. Who could file their Tran 1, but they have made mistake and they could not revise it within the timeline. And certain application they could not file their Tran 1 because of technical glitches and submitted their application to IT Grievance Committee, which was formed sometime in April 2018. But their application got rejected on the pretext that there was no technical glitches. So we have seen many litigation. Maximum High Court has given judgment in favor of a taxpayer, and those cases were pending before Honorable Supreme Court. At one stroke, I must say, more than 400 cases are now being directed. The government has taken a call, and principally they have agreed upon that this benefit must be passed on to the aggrieved taxpayer. They have prepared a note, and this note was prepared by the Council from the Union of India and submitted before the Honorable Supreme Court, which is accepted by the Supreme Court in verbatim as such. And now Honorable Supreme Court, in the case of Philco Center Private Limited, has directed, and these are important points. What is being directed? Directed to CBIC to open a window on GST Common Portal for 60 days, starting from 1st September 2022 to 31st October 2022. And this benefit would be available not only to the petitioner who have filed the writ petition, but to all aggrieved taxpayer who could not get the benefit of availing pre-GST credit by way of transition. They could not file Tran 1 or Tran 2 because of technical glitches or procedural lapses. Now this window would be available to all such aggrieved taxpayer. Now this window would be open for 60 days on GST Common Portal. Then it is being stated in the direction that there will be 90 days in the hands of field formation or field officer to check and verify such claim, and they must pass an order, reasonable order on merit, and then this amount should be credited to the e-credit ledger of such aggrieved taxpayer. And it is being estimated that there is around 500 crore rupees lying and under litigation before Honorable Supreme Court. And with this one direction, these cases are being resolved. There would be window of 60 days and 90 days window in the hands of field officer to do check and verification. It is also being stated in that particular Supreme Court direction that GST Council can prepare a standard guidelines for checking and verification and allowing this credit, transitional credit of pre-GST regime to GST regime, because Tran 1 and Tran 2 could not be submitted because of technical glitches, procedural lapses, and many factors around. And importantly, we must agree that this credit is a vested right in the hands of taxpayer in terms of Article 300 capital A as being held in one of the judgment by Punjab and Haryana High Court in the case of Advert Technologies Private Limited, which was upheld by the Honorable Supreme Court. In the case of brand equity by Delhi High Court judgment, it is being said rules are only procedural, directory in nature. They cannot take away substantive right of a taxpayer. So, lot of judgment was pending before the Supreme Court because SLP was filed by the Revenue Union of India. Since this particular note prepared by Council of Union of India, which is accepted in verbatim by Honorable Supreme Court and direction is being issued, laudable one and appreciating one. So around 500 crore rupees transitional credit which is under litigation, and for around 7,000 to 10,000 taxpayer, this is a great relief. They will get their transitional credit. So benefit going to be available to whom? जिनने अपना Tran 1 और Tran 2 नहीं भर पाए because of technical glitches, या जिनने भरा बट गलती हो गई उनसे, रिवाइज नहीं कर पाए, या फिर जब उनकी एप्लीकेशन आईटी ग्रीवेंस कमेटी को गई तो आईटी ग्रीवेंस कमेटी ने ये कह के उनकी एप्लीकेशन को रिजेक्ट कर दिया, देयर वाज नो टेक्निकल ग्लिचेस. और ये भी प्रॉब्लम आ रही थी कि लॉकशीट, बैकलॉग शीट ये देख रहे थे कि टैक्सपेयर ने बाय ड्यू डेट 27 दिसंबर 2017 जीएसटी पोर्टल पे लॉगिन किया था, क्या ट्रैन 1 भरने की कोशिश की थी, ये लॉकशीट देखी जा रही थी. बहुत सारे फैक्टर्स थे. इस ऑनरेबल सुप्रीम कोर्ट के डायरेक्शन से एक फायदा और बड़ा फायदा उन सभी टैक्सपेयर को हुआ जिनको प्री जीएसटी की क्रेडिट जो नहीं मिल पाई थी, जो ट्रांजिशन नहीं कर पाए थे बिकॉज वो ट्रैन 1 या ट्रैन 2 नहीं भर पाए, टेक्निकल ग्लिचेस, प्रोसीजरल लैप्सेस, या भर दिया पर गलत भर दिया, रिवाइज नहीं कर पाए, उन सब के लिए विंडो ओपन हो गई. यानी कहने का मतलब ये हुआ कि जो जिनने रिट पिटीशन फाइल की उन पिटिशनर को भी, और जिनने रिट पिटीशन फाइल नहीं की है बट वो एग्रीव टैक्सपेयर हैं, उनकी ये राइट जो वेस्टेड राइट है, दिस क्रेडिट इज ए वेस्टेड राइट इन टर्म्स ऑफ आर्टिकल 300 कैपिटल ए टू द कॉन्स्टिट्यूशन ऑफ इंडिया. और दिल्ली हाई कोर्ट का अगर हम ब्रांड इक्विटी का जजमेंट देखें तो उसमें कहा रूल्स आर ओनली प्रोसीजरल, डायरेक्टरी इन नेचर, that cannot take away substantive right of a taxpayer, and it was allowed they could and they can file their writ petition till 30th June 2020. 3 साल का लिमिटेशन पीरियड उन्हें अलाउ किया था, बट इतने सारे केस, मोर देन 400 केस वॉज पेंडिंग बिफोर ऑनरेबल सुप्रीम कोर्ट. गवर्नमेंट ने इस बात को समझा, उन्हें एग्री किया, एंड काउंसिल फॉर द यूनियन ऑफ इंडिया ने एक नोट सुप्रीम कोर्ट को दिया. उस नोट में उन्हें ये मान लिया कि ठीक है, और उसको सुप्रीम कोर्ट ने एक्सेप्ट भी कर लिया वर्बेटिम, और उन्हें एक डायरेक्शन दिया है इस पर्टिकुलर जजमेंट में कि एक स्पेशल विंडो 60 डेज की ओपन की जाएगी फ्रॉम 1 सितंबर 2022 टू 31 अक्टूबर 2022. उसके बाद 90 डेज का टाइम पीरियड फील्ड ऑफिसर के हाथ में दे दिया कि वो इस एप्लीकेशन को चेक करें, वेरीफाई करें और एप्रोप्रिएट ऑर्डर पास करें. उसके बाद जो ट्रांजिशन क्रेडिट इनको मिलनी चाहिए वो ई क्रेडिट लेजर में चली जाए. ये तो अच्छा जजमेंट रहा, बट नाउ इम्पॉर्टेंट, देयर मे बी लॉट ऑफ टैक्सपेयर who have tried to file Tran 1 and Tran 2, and for either of region their application got rejected, and they have also paid the liability. यानी जो क्रेडिट उनने ली थी, they have reversed the liability, maybe along with interest or penalty. What happened to such aggrieved taxpayer? Those who have already reversed because their application was rejected, so are they going to get the benefit? Because they are also entitled to. They were also pleading before the authority, sir, we could not submit Tran 1 and Tran 2 on time because of technical glitches. but this credit was available. But beyond 27 December 2017, maybe field officer, they have rejected their application and demanded reversal from them along with interest or penalty, and some of the taxpayer may have paid the liability also along with interest and penalty. What happened to them? Whether this benefit, and this must be given to them as well, they must also get the benefit, उनको भी ये बेनिफिट मिलनी चाहिए. जब हमने ये स्पेशल विंडो उन सारे एग्रीव टैक्स पेयर के लिए ओपन की है जो ट्रैन 1 ट्रैन 2 नहीं भर पाए बिकॉज ऑफ टेक्निकल ग्लिचेज और प्रोसीजरल लैप्सेस, अगर आपने उनसे कलेक्ट कर लिया है, डिपार्टमेंट ने उनसे कलेक्ट कर लिया, रिवर्सल करवा दिया है, उनसे इंटरेस्ट ले लिया है, allow them refund and get them this credit reinstated in their e-credit ledger. Maybe this part, when GST Council is preparing SOP guidelines, that how this field officer are going to check and verify, a special window should also be given to those जिनने रिवर्सल कर दिया, उनको भी मिलना चाहिए था. जिनने रिवर्सल अलॉन्ग विथ इंटरेस्ट कर दिया, उनको वो रिफंड इंटरेस्ट का, पेनल्टी का मिलना चाहिए. थैंक्स फॉर वॉचिंग. स्टे ट्यून. थैंक यू वेरी मच.